Hello to all our viewers and our machinist members that are tuning in each week. This is the 141 Report, and I'm your host, Dave Lehive, a communications representative for District Lodge 141. This week, our Zoom interview travels back to Chicago, Illinois, to have an interesting discussion about legal issues and tips for our members. We'll be speaking with attorney Frank Marco, who will be counsel for I am District Lodge 141. Before we start, please remember to like our Facebook page, follow our Twitter page, subscribe to our YouTube channel. Through your solidarity in helping in these three ways, we are building a huge communications network for our membership. So let's get started as our 141 report starts now. Hi, Frank. Thanks for joining me today. Can you please tell the viewers about yourself? And can you give our viewers a little history about your educational background, the degrees you have received, and your current specialty in legal representation?
Absolutely. Thank you, Dave, for having me. I do appreciate the time to speak to you as well as your members. I'm an attorney, as you mentioned, working out of Chicago, Illinois, from the law firm of Gregorio and Marco. I've been practicing law for about 30 years. Time flies, as you're having fun, but it's just over 30 years now. And I've been representing labor unions for over 25 years now. I started out doing bankruptcy work for whatever reason. I was really interested in that, but then moved into the labor field after about 5 years of practice and haven't looked back since. I do enjoy working with the membership as well as the local union leadership and helping people, work and get paid for quality work that they're doing and help them with training and benefits and whatever else goes into the workplace. My practice includes primarily representing labor unions. We represent District Lodge 141. We also represent various other building trade unions, the ironworkers, plumbers, both nationally as well as in the city of Chicago. I'm the general counsel for the International Ironworkers Union. And so I do travel a lot around the country working with them and their various unions. Particularly distressed unions, trying to help them get out of whatever trouble that they're in order to get back to representing the members primarily, rather than dealing with financial issues or Department of Labor investigations or what have you. So that gives me a wide breadth of understanding in terms of what the regulatory environment is that governs labor unions. Labor unions are highly regulated in today's world, more so than I think any other business. And so there's a lot of traps out there and a lot of areas for us to work with the leadership on. I went to undergraduate college at Marquette University in Milwaukee, Wisconsin, and went to law school at Cornell Law School. Graduated from there in 1990 with a practice in litigation. After that, as I mentioned, I've been practicing labor law for the past 25 years and really find the work rewarding.
Okay. So when did you start officially working with District Lodge 141? How many years ago was that?
Well, that was probably about 10 years ago, off and on. We started working with the local 1487 out of Chicago many years before that, perhaps even 20 years on a formal and informal basis, dealing with all the questions that they might have with regard to representation of the members and also the work that they were doing. We were then brought into, as our contacts there kind of were promoted and moved up the chain, that they brought us in ultimately to 141. We met with the leadership there and have been working with them off and on for 10 years. Each year we get a little more, there are different, since it's a national union. There's different groups that are used to attorneys in different parts of the country. So we've been gradually, slowly expanding our base from Chicago and beyond. So we work with many of the AGCs across the country now, dealing with grievance arbitrations and things that stem from that, whether it's a wrongful termination lawsuit, a discrimination lawsuit, EEOC charges, and things of those nature. So
Okay.
it's been a developing relationship, and we enjoy it quite a lot.
Yeah, the Railway Labor Act is a total different laws compared to the National Labor Relations Board. You primarily trained in RLA labor law?
No, both. We're familiar with both. In my law firm, we have 6 attorneys that deal with labor unions. One of them more specializes in the Railway Labor Act, but pretty much everybody has to have a general understanding of what the laws. And although the laws are quite different under the RLA than the NLRA, some of the principles remain the same. You know, the duty of fair representation, concepts remain the same.
Okay, great, great. What would you recommend to our stewards that are out there in the field every day that are dealing with, investigations and what? What are the tips that you would recommend to those stewards about how to handle those investigations?
Well, first of all, Dave, I think that your stewards do a fantastic job representing the employees as well as documenting it. And from my perspective, that's always the problem we experience with other local unions is that they may have had interviews, they may have taken witness statements, but their notes are few and far between on the subject. So I believe that 141 does a fantastic job, and the stewards themselves do a fantastic job of following up on things and taking notes and taking witness statements and taking notes of the hearings. So we appreciate that tremendously, because when it does come to us 6 months down the road, unfortunately, sometimes it will. If it does come to us that way, witnesses' memories all change. So getting those contemporaneous records are absolutely essential. So we do appreciate that. My first recommendation to them would just be to, be thorough and don't prejudge something, so everybody, most of the stewards know the individuals that might be accused of some violation of a UAL rule or something like that. And there's always a human tendency to say, yeah, this guy's always late, or this guy always did that. But everything starts from scratch. Let's look at each individual charge that's against a member individually on its own merit, interview all the witnesses, and base it just on the facts. One of our obligations is that we have to proceed in good faith and treat all our members the exact same as any other member. So whether an individual likes somebody or doesn't like somebody, or trusts somebody or doesn't trust them, we always have to go through all those steps, document each statement and each step along the way. Every phone call you make, document it to show that you're doing your job. And then and ultimately when a decision is made, whether it's by UAL or by the local union, if it decides not to pursue a grievance much further or to compromise, the key is that you've taken all these steps to gather the information that you need so you can make an informed decision. You can't make the right decision if you don't make an informed decision.
Understood. Okay, great. So I have another question that we have is, can companies, we're dealing with a pandemic right now. And the question that we keep hearing from our members, with this COVID vaccine that's out there, what are what's permissible and what's not permissible by a corporation? Can they tell you have to take a vaccine?
Yeah, absolutely, that they can. And the EEOC has made that clear, to the extent there is some ambiguity about it. And one of the reasons is it's for the safety of everybody, not just one individual, but people work in a community, people work in a group. People work indoors, and this is an airborne virus, and it's very transmittable, and it's actually getting more transmittable every day for whatever reason. And so companies have to keep everybody safe. And the EEOC has given them, clearance to mandate vaccines and mandate, testing and things like that, temperature checks and things like that, to make sure that people are all healthy when they get to work and not posing a risk to the other individuals. They do have to make some accommodations, so we always have, whenever there's a mandate for a vaccine or for a test, we always have to make an accommodation for certain groups of people. One would be people that have a disability. So some people can't take a vaccine. Some people have an immunocompromised situation such that their doctor is telling them that this would be dangerous for you. I think they're getting more comfortable with women who are pregnant getting vaccines or getting tested and things like that. But at first, like, they were also very wary about that, because when these vaccines were being developed, they never did testing on pregnant women, because that's a additional risk for them. And in Operation Warp Speed, anything that slows you down was kind of being left for later. But doctors are getting more comfortable with that. But in any event, if a doctor tells an individual that they cannot take a vaccine, the employer has to accommodate that if reasonably possible. So for a lawyer, many of us can work remotely. We're all working remotely right now to a certain extent. The courtrooms were even shut down for about 6 months, where you didn't have live hearings. So our attorneys could work remotely and do all the work that they're normally expected to do. That doesn't work with every industry. You can't be a waitress or a waiter and work remotely. You have to be there with the customer. And so depending on the situation, that accommodation can either be made or not made by the employer. The other accommodation is a religious accommodation. Traditionally, our country has always allowed for a First Amendment religious exemption to any mandates by employers that would infringe upon that. It has to be a sincerely held religious belief, but the employer would have to make an exception if somebody does have that. So that with those two exceptions, the employer certainly can mandate the vaccine.
Okay. We deal a lot with social media nowadays. A lot of our members use social media. We talk about this in our education classes about the pitfalls of social media. What is permissible and what is not permissible on social media when you work for a corporation?
Well, generally what's not permissible is anything that really is a negative attitude towards the employer, towards the company, or towards your coworkers, or towards racial ethnic groups. Many employers are coming up with social media policies as we speak that prohibit discriminatory conduct, discriminatory comments. Social media posts, it's very easy to post something in the privacy of one's home or on their phone while they're sitting on the couch. But you have to always, my recommendation to your membership is always think like, if this is something that you want your children to see, because it's going to be around forever. Is this something you want your grandchildren to see? If we're angry about some coworker and something that happened at work, that's understandable. And you can talk to your steward about that. You can talk to the union about that. We're here to help you. But once you start posting it on social media, if the employer takes a look at this and says, well, this guy's making racist remarks, discriminatory remarks that could be construed in today's world as being, harassing, we might have to discipline this guy. We might have to get rid of this individual, depending on the situation. Now, very often our collective bargaining agreement, might help us in terms of handling a grievance like that. But if you ever look at what you post on social media, if it's something like that, and all of a sudden the employer gets it and you're before a grievance hearing, and you look at those words, take them out of the context of you being angry, and look at them on a piece of paper and say, is this something you want to be able to defend 6 months down the road? And if the answer is no, put the social media device down, don't make the post, give yourself 24 hours to clear your mind, and then make a rational post if that's what you want to do. So it's something that's getting a lot of people terminated nowadays. And it doesn't matter if it's something that happened 3 years ago, 5 years ago, 7 years ago. This stuff lasts forever.
Yeah, well, we're seeing that. It happens a lot in the news. You'll see those posts coming up. Politicians are being dogged on it, and actors
Absolutely.
and actresses, and like you said, sports figures. It happens all the time. So great advice. So how important is it today for workers to have union rights and a collective bargaining agreement?
Oh, I think it's essential. And I wouldn't say it's more important than ever. You know, there's always time periods where you think that your rights are under attack, but our rights right now, our union rights, our collective bargaining rights, are certainly under attack across the country right now as we speak. You know, unions got strong in the 30s and 40s, and their membership grew exponentially during this time. There's always been a law and a policy by the federal government in favor of unionization and people's ability to bargain collectively. It's proven to be the absolutely most essential tool if somebody wants to either create job stability or increase their income. People that work under a union contract make significantly more than people that don't work under a union contract. That goes that's across the country. Um, and right now it's under attack. People are losing their collective bargaining rights in states and municipalities. The Janus decision, if your members are familiar, was a case that was very famous a couple years ago. That eliminated collective bargaining rights for municipal and state employees across the country. One decision. People were pursuing that case for a number of years, and they finally got the right makeup of the Supreme Court, and the case was reversed, and now the laws are different, and it's going to be a lot harder for state employees to work productively and negotiate higher wages, because now people can opt out of the union without opting out of their job. They can stay there and be free riders, and that hurts everybody's ability to negotiate better terms and conditions.
Yeah, well, that's one of the things that we're pushing for right now in Washington, D.C. is the PRO Act.
Yes.
And that'll help us out tremendously. So our workers want to find information, make sure they do look up the PRO Act and contact their legislators, because it's a very important piece of legislation. For any of our non-union airline workers that may be watching our program today, they don't have a union contract. Would you encourage them to organize and join a union?
Oh, I absolutely would. And first, you know, it is about the terms and conditions of employment. You know, so if somebody's looking to better their wages without, you know, leaving their employer, it's by far the best, most proven way to do so. But it's also in terms of creating a work environment that's understandable to a wide, diverse base of employees. If you look at a workplace, people can be terminated for no reason for the most part across the country. At will employment is what it is. As people have worked in a company, if you have 20 years of experience, a stellar record, a lot of times under a collective bargaining agreement, if you violate the rules, there'll be progressive discipline. You're not going to get terminated for one minor offense. But in the private sector, outside of the union contract text, that's not the case. And a lot of times employers are looking to save money wherever they can. The 20-year veterans making a lot more than the 2-year person who just kind of came in a little bit ago. Their health costs are higher, their health risks are higher. Perhaps they might think that their workers' compensation charges are higher with older, or risk are higher with older individuals. So a union contract will protect you as you progress through your work life to make sure that you're treated fairly. And whatever the work rules are, they're negotiated with your union so that you have a collective bargaining agreement that lists what these work rules are. And if you follow those rules, you're not going to be brought up on any grievance charges or terminated. You're going to be able to work under that environment successfully because you know what the rules are, you play by it, and the employer knows what the rules are, and hopefully they play by it as well. So yeah, I believe it's very important for the non-union guys to organize and join unions to bargain collectively.
Yeah, thanks for that information. Closing question: is there anything you might want to mention before we close out the interview? Is there something that maybe you forgot to talk about, or something that you feel that would be important that our members know?
Well, I not particularly, Dave. I think that you covered a wide variety of questions. I will say that we do enjoy our work with District Lodge 141. And we have worked with their AGCs, and something that needs to be said. You know, it's difficult working in an environment for a career, but everyone's got to trust everyone and everyone's different roles in this environment. The members have to trust their stewards. You know, people they may think that their stewards not trying to help them or they're not doing enough, but their stewards are doing as much as they can to help each individual, no matter what the grievance charge might be. And the AGCs, you know, when it gets to their level, they're also there to help the membership. We're all working to help the membership either negotiate better terms and conditions of employment or be treated fairly within the workforce. And that's what everybody is geared towards. So the employee has to be honest with the steward and honest with the AGC, and the AGC has to be honest with the individual, saying, we've analyzed your case. Here's what's going to happen. We know what UAL does under these circumstances because we've been dealing with them and we keep a record of it. So here's what's going to happen, and here's our best argument. And sometimes an employee thinks he has to kind of spin things a little bit or shade things, but you always got to be the most honest with your steward and with the AGC, and then they'll put forth the facts that help your case the best. So I kind of think that a trust environment is one of the most important keys to both the attorney-client relationship as well as the member steward AGC relationship.
Okay. Well, Frank, this is the end of our interview. I appreciate you coming on the 141 report today and taking the time to give our members some really good advice and some good information.
Thank you very much, Dave.
It was great seeing you. Have a great day now, okay?
You too. Very good.
All right. Well, this wraps up the 141 report. And to all our viewers, thank you for tuning in. Remember to stay safe, wear your mask, and have a great weekend. Bye for now.